Good afternoon. Today is Tuesday, June 30th, 2026, and we are going to go over Officer or ex-Lieutenant Detective Brian Tully's motion to quash his deposition. He's I don't know what number he is in line, but he is just the latest of the group of witnesses that Karen's team has called to depose, and they have either not shown up or tried to reschedule or tried to just cancel or whatever. There's a long line of them. Colin Albert was the most recent until now, and now it's Brian Tully. So hang on and we will get right to it. So, this debacle of a wrongful death case that the O'Keefes have brought against Karen Reed is something else. I mean, I feel sorry for this judge. He's at his wit's end with these depositions and the people's lack of respect for the justice system in serving these deposition subpoenas. And it just goes to show you how much respect they actually have for the justice system in total. This particular group of people, they have absolutely no respect for the law. They think they're above the law. I think they've proven that numerous times before, and they just think that they don't have to answer to anybody and they can do what they want. And it starts at Michael Morrissey's office and it works its way all the way down to the Haas defendants, or the should have been suspects. It baffles me how they are continually protected by the same law enforcement that they obviously truly disrespect and have no consideration for and don't take seriously. So why these people feel the need to protect the should have been suspects, who knows? Maybe the should have been suspects have something on them. I don't know. But I mean, these guys, this group of people blatantly disrespect and defy the law, and it's the law that keeps protecting them. So I'm not quite sure how that works out, but it does, and it's pretty shocking. So we are going to read Brian Tully's motion to quash his deposition. He feels like he has no business being deposed. He wasn't a part of the Karen Reed investigation. These are his words, basically, not mine. And so he has no business. He has nothing to offer, nothing to bring to the table, so to speak. And it's just like, are you kidding me? First of all, you were Proctor's boss. You were his commanding officer. So whatever case he's involved in, you're involved in, because whatever he does under the badge, so to speak, reflects on you, and you're ultimately the responsible person for his actions. So everything that is coming out about Proctor right now reflects on you. Not to mention, you were included in several of those chat threads on his text messages. So it's only a matter of time before whatever you're trying to hide comes out too. And so just come clean now. You've got to know that the walls are tumbling down around the Canton Police Department, the Massachusetts State Police, the Norfolk DA's office. The walls are coming down, and you're better off getting in front of it than answering to it, I think. I don't know if your retirement is on the line because of it, but it doesn't matter. If it is on the line, you're going to lose it one way or the other. I would think, or I would hope, that you would be the bigger man and just come clean and take your lickings. I mean, Karen Reed especially, but none of us are giving up until the right people are behind bars for Officer John O'Keefe's murder, and those that were involved in the cover-up and the persecution of Karen Reed are being held accountable for their actions or inactions, whichever. Also, Sergeant Good's text messages, or the IA investigation against ex-Sergeant Good from the Canton Police Department has been released. And I didn't think it would be possible, but they are actually, I think, a little bit worse than Michael Proctor's, to be honest with you. I mean, he is a misogynistic prick. I mean, the things he's married too, right? I mean, he wears a wedding band. So I wonder if he's going to be married after this, because he has absolutely no respect for women. None. He is a pig in it at its finest. And I mean, and that's an insult to the pigs, to be honest with you. The poor farm animals don't deserve to be compared to Sergeant Good. He's just, the stuff that is coming out is so bad that it's embarrassing to even read, much less speak out loud. I mean, how people can feel this way about other races and other genders that have never done anything to them is beyond me. I mean, this is sickening. And you got to wonder, where did it come from? Somebody had to instill this in them. You don't get this much hate and vitriol towards another race or another gender without it being learned into you, right? I mean, these guys sound like they belong in a KKK clan. I mean, I'm expecting when they do, if they were to serve a search warrant on Goods or Proctor's home, I'm almost expecting them to find the black steel-toed boots with the red shoelaces, the red suspenders, and the typical outfit of the white supremacist party. That's how bad they are. It's crazy. So I will do a video on those and the outcome of that IA investigation probably later on tonight or tomorrow, and it'll be up tomorrow or the next day. And also Karen Reed's opposition to the motion that we are reading today. Her opposition to Brian Tully's motion to quash his deposition will be up either later on tonight or tomorrow also. So yeah, it's been a busy weekend. I worked all weekend, so I couldn't get any of these done before now. So sorry about that. I just sat on them all weekend, and they were just burning a hole in my pocket because I wanted to, stream on them. That there were pretty big motions and whatnot, and pretty big findings coming out, and I couldn't stream on them because, I was working. I worked 12-hour shifts, night shift, and it's impossible to try and get anything done in the 12 hours you're off in between shifts. So when you work a stretch, that's all you do. So we are going to get right into it. Does anybody have a lot of big plans for the 4th of July? I think we're going to stick around the house. It's too scary to leave the house anymore on holidays like that. Too many assholes out there trying to prove something or see who can make the most noise or make the most trouble. And I don't want any part of it. And I don't want my house to be a part of it. So I'm just Whoops. Wrong thing. I was going to cover that after the end of this. I hope I didn't give it away. So let's stop sharing and share again. Sorry about that. I'm going to clean off my glasses real fast. Sorry. I hear about all the things going on in the Karen Reed world, you know, between the different creators, and I don't want to get involved. I like everybody the same. I think they all have their own contributions to make to YouTube and to the Karen Reed movement and the Free Turtle Boy movement. The only one thing I am going to say, and this is mainly to the outsiders of the movement, or the antis, I should say, and some of the reactors who just react to the different creators' videos, is, you know, we try to teach our kids not to bully. And all I've seen on the tubes of you over the last couple of weeks is nothing but bullying. And I just have to, the only thing I want to say is grow up. We're above this. The name calling, the body shaming, the attacks on creators' families, and bringing kids into it. It's all ridiculous. We're here to entertain. We're not here to change anybody's life, I would think. Most of us aren't anyway. The Karen Reed thing was a fluke. It was a unicorn. Yes, we helped, you know, I would like to say we helped change the trajectory of her life, but ultimately we're here for entertainment. And when you start attacking people personally and their families and body shaming and name calling, you're no better than the bully on school grounds, you know, and that's not tolerated anymore. Even though I still think that kids need to learn how to stand up for themselves, you know, the playground bullies shouldn't be, you know, persecuted as badly as they have been, because every kid needs to learn how to stick up for themselves, and kids are weaker now because they don't have to stick up for themselves in any situations because their parents are always right there to save them. But still, I mean, you know, fun is fun, satire is satire, but when you start attacking people's looks and family and kids, you've gone too far. So, I mean, for what it's worth, nobody will probably listen to me, but I'm just saying, can we just play nice in the sandbox? I mean, that's all I'm saying. Okay. Motion of non-party witness, lieutenant, and I don't know why they're saying lieutenant. He is no longer a lieutenant. He was demoted to detective. So, motion of non-party witness, Lieutenant Brian Tully, retired, to quash subpoena and or for protective order. Introduction. Non-party witness, lieutenant. It really bothers me that they call him lieutenant because he was demoted before he retired. Lieutenant Brian Tully respectfully moves this court, pursuant to Massachusetts Rules of Civil Procedure, to quash the deposition subpoena and accompanying document requests served upon him by defendant Karen Reed, or in the alternative, to enter a protective order limiting the scope of examination and production. This motion rests upon two independent and compelling grounds. First, the subpoena is not a legitimate exercise of discovery directed at a disinterested third party. It is directed at a retired law enforcement officer who is simultaneously a named defendant in Karen Reed's own federal civil rights lawsuit. Right. So what you have to bring to the table is definitely important. That's why you're subpoenaed to depose in this, as well as you're being sued because you were a part of the investigation. A lawsuit in which she has asserted 7 causes of action against him arising from the identical events and subject matter that are the focus of Schedule A's 15 document request categories. Formal discovery in that federal action has not opened. Okay, but that's a totally different case. That has nothing to do with this case. The federal court has scheduled a hearing on Lieutenant Tully's pending motion to dismiss for July 14th, 2026, 6 days after the deposition commanded by the subpoena. Karen Reed may not accomplish through a third-party subpoena in this proceeding what the federal pleading standards, the pending motions to dismiss, and the federal court's case management authority have not yet permitted her to do in her own case. 2 totally separate cases. I don't think he gets that. Second and independently, the 15 categories of document requests in Schedule A are facially overbroad, disproportionate to any legitimate need in this wrongful death action, and impose an undue burden on a retired supervisory officer who was not a primary investigator in the underlying matter. No, but the primary investigator was your subordinate. So you have to answer for his actions. For these reasons, the subpoena should be quashed in its entirety. At a minimum, a protective order is warranted staying the deposition pending the federal court's July 14, 2026 hearing on the motions to dismiss and the resolution thereof, and substantially narrowing the document requests to categories that are relevant, proportionate, and not otherwise obtainable from the party defendants. Well, I would say that the documents she's requesting are very relevant. If they're not obtainable, just say so under oath. Procedural and factual background. A, the O'Keefe civil action and the subpoena. This action arises from the death of John J. O'Keefe III on or about January 29, 2022. I'm just going to say Tully because he's not a lieutenant anymore. Tully is not a party to the Plymouth County Superior Court action. He is a retired Massachusetts State Police lieutenant who served as a supervisory officer at the Norfolk County State Police Detective Unit, where he had supervisory authority over the detective unit assigned to investigate Mr. O'Keefe's death. He was not a primary investigating officer and did not personally conduct interviews, execute warrants, prepare affidavits, or make charging decisions in connection with the investigation. And I have to say, call bullshit on that because he did execute warrants. I know he executed the warrants to secure Dr. Reed and what's her brother's name? Their bank accounts to see if they bought Turtle Boy a new Lexus. And that has everything to do with this case. That was this case that he was executing those warrants for. He wanted to find, and then he did do an interview. He flew to LA with Buchanan, I almost said Bukaki, to interview Natalie, the German. That had to do with this case. On May 5th, 2026, defendant Karen Reed caused a subpoena to be served upon Tully through his counsel, commanding production of documents by June 1, 2026, and his appearance for deposition on June 11, 2026. So he's known about this since May, and they asked for a continuance, I believe. The deposition has since been adjourned by agreement to July 8th. The document requests set forth in Schedule A to the subpoena, a true copy of which is attached hereto as Exhibit B, comprise 15 categories that sweep across virtually every communication, document, recording, email, and text message touching the O'Keefe investigation, the Canton Police Department, the Boston Police Department, the Norfolk District Attorney's Office, Karen Reed herself and her representatives, the Albert family, and Tully's own MSP disciplinary proceedings spanning a period in excess of 5 years from January 1, 2021 to present. The parallel federal civil rights action and the motions to dismiss. On November 17, 2025, Karen Reed filed a civil action in Bristol Superior Court naming Tully as a defendant, which was subsequently removed to the United States District Court for the District of Massachusetts civil action, period. Tully promptly filed his initial motion to dismiss the original complaint, arguing that the complaint failed to state any plausible claim against him. Rather than oppose that motion, plaintiff filed an amended complaint on March 13, 2026, substantially expanding her allegations against Tully across 7 counts. Malicious prosecution, count 1. Supervisory liability, count 2. Conspiracy to deprive plaintiff of constitutional rights, count 3. The Massachusetts Civil Rights Act, count 4. Common law malicious prosecution, count 5. Intentional infliction of emotional distress, count 6. And civil conspiracy, count 7. The pattern of the amended complaint's expansion is telling. Rather than supply new facts, plaintiff principally inserted Tully's name into allegations previously directed at other defendants and added new, quote unquote, upon information and belief allegations without any supporting factual foundation. Just 1 second, I'm going to take a drink. I never have cotton mouth until I start to stream, and then I get cotton mouth. It's crazy. On April 3rd, 2026, Tully filed his motion to dismiss plaintiff's amended complaint pursuant to, and it gives the statute. A true copy of Tully's motion is attached hereto as Exhibit A. As set forth in detail in Exhibit A, the amended complaint fails to state any plausible claim against Tully for the following independent reasons. 1, the complaint relies on conclusory assertions unsupported by specific facts in violation of Ashcroft versus Iqbal and Bell Atlantic Corp v. Twombly. 2, the complaint engages in impermissible group pleading that fails to distinguish Tully's supervisory role from the conduct of the primary investigating officers. 3, Tully is entitled to qualified immunity on all claims. 4, the state law claims in counts 4 through 7 are barred by the Massachusetts Tort Claims Act. Judge Casper has scheduled a hearing on the pending motions to dismiss for July 14, 2026. Formal discovery in the federal action has not opened. Tully has not been deposed, has produced no documents, and has answered no interrogatories in that proceeding. This subpoena was served on May 5th, 2026, 32 days after Tully filed his second motion to dismiss, and commands Tully's deposition on July 8th, 2026, 6 days before the federal court is scheduled to hear argument on whether any claims against him will survive at all. This is a different case. You're not a defendant in this case. You're a witness. They're 2 totally different things. The federal court has already declined to authorize pre-conference third-party discovery in this litigation. The impropriety of this subpoena is further illuminated by a development in the federal action itself. Co-defendant Michael Proctor, through counsel, filed a motion in the federal action seeking leave to conduct limited pre-conference discovery directed at third parties, specifically keeper of records subpoenas to the Norfolk County DA's office and the Canton PD, in order to refresh his memory and prepare for his own deposition in this Plymouth Superior Court proceeding, which was scheduled for June 8th, 2026. Yeah, because remember, they emailed Karen Reed and tried to get the data and stuff that she had to help him prepare for his deposition. I mean, talk about the balls and the audacity. How dare you ask her for her help after what you've done to her and are still doing to her? Proctor argued that, quote unquote, good cause existed for pre-conference third-party discovery because Karen Reed's counsel, who represents her in this Plymouth case as well as in the federal action, had refused to provide him with any materials with which to prepare for that deposition. Karen Reed opposed Proctor's motion. Judge Casper denied it, attached hereto as Exhibit C. The significance of that ruling for the motion now before this court is direct. Judge Casper has determined that pre-conference third-party discovery touching the subject matter of the federal action is not appropriate, even where a federal defendant faces an imminent deposition in this parallel state court proceeding and lacks access to the materials he needs to prepare. Yeah, it's about right. Having obtained that ruling by opposing Proctor's motion, Karen Reed cannot now be heard to argue that this court should compel Tully, a named federal defendant in her own lawsuit, to submit to a wide-ranging deposition and produce 15 categories of documents in advance of the federal court's July 14th hearing on the motions to dismiss. The federal court has effectively signaled that discovery in this litigation in any direction awaits the Rule 16.1 and Rule 26 process. Karen Reed cannot invoke that ruling for her benefit in federal court while simultaneously using this court's subpoena power to an end run around it. For her benefit in federal court while simultaneously using this court's subpoena power to an end run around it. Argument. The subpoena should be quashed or stayed because it is an improper attempt to circumvent the discovery framework of the parallel federal proceeding in which Tully is named a defendant. Rule 45B of the Massachusetts Rules of Civil Procedure authorizes this court to, quote unquote, quash or modify the subpoena if it is unreasonable and oppressive. Rule 26C independently empowers the court to issue a protective order, quote unquote, for good cause shown to protect any person from, quote, annoyance, embarrassment, oppression, or undue burden or expense. Well, what about all the annoyance, embarrassment, oppression, and expense that you caused Karen Reed for 3 years? And ongoing, I might add. Together, these provisions confer broad discretionary authority to regulate subpoenas that are directed at non-party witnesses for improper purposes. The subpoena here is not directed at disinterested third party, The subpoena here is not directed at a disinterested third party. Tully try it one more time. The subpoena here is not directed at a disinterested third party, period. Tully is simultaneously a named defendant in Karen Reed's own federal civil rights lawsuit in which she has sued him personally on 7 causes of action arising from his role as a supervisory officer in the O'Keefe investigation. The same investigation that is the subject of this wrongful death action and the same subject matter that is the focus of every one of Schedule A's 15 document request categories. The overlap between the federal action allegations and the Schedule A categories is complete and unmistakable. A third-party subpoena cannot be used to circumvent federal discovery limitations. Courts have consistently recognized their inherent authority to stay or quash subpoenas where the practical effect is to circumvent the discovery framework of a parallel proceeding. I don't think that's what her intentions are. McGuire versus Cunningham. Recognizing court's inherent power to manage discovery to prevent prejudice and abuse of process. Micro Financial Incorporated versus Premier Holidays International Incorporated. Courts may coordinate and stay parallel civil proceedings to protect litigants' rights. And in another case, granting stay of discovery in parallel proceeding to prevent circumvention of case management order. The rationale is straightforward. If discovery has not yet opened in the primary proceeding in which the witness is a named defendant, permitting the adverse party to obtain functionally identical discovery through a third-party subpoena in a related case frustrates the orderly management of litigation and deprives the defendant of the protections afforded during the pre-discovery phase of the primary case. Okay, well, this isn't a related case. These cases just happen to revolve around the same incident. But the wrongful death case is a totally separate case than what he is being accused of by Karen Reed and her civil action against him. Okay. Albeit she would never have been in the situation to have her rights violated by him had she not been charged with John O'Keefe's death. Yes, so that is directly related. But other than that, the two cases are two totally different animals, and they need to keep them separate. Those protections include, critically, the threshold determination by the federal court of whether the complaint against Tully states any plausible claim at all. The determination is now imminent. Judge Casper has scheduled a hearing on the motions to dismiss for July 14th. So is he saying that if she finds that if she dismisses the case against Tully that Karen has filed, is he saying that he doesn't need to be deposed as a witness in this case? Because that's totally not true. He's still a witness in the wrongful death case. So if those charges get dismissed, he still has to answer to the deposition or the subpoena to be deposed in the wrongful death case. So I think he's hoping that if the case gets dismissed against him by Karen Reed, that he won't be expected to depose for the wrongful death case. And I think he's seriously wrong about that. And I think he's going to be very disappointed to find that out. If the federal action is dismissed following that hearing, as Tully's briefing argues, it should be on multiple independent grounds. A deposition conducted on July 8th will have served no legitimate purpose in this wrongful death action, while imposing upon Tully the full burden of federal defendant discovery through the back door of a state court subpoena on the eve of the federal hearing. Well, no. A deposition will serve a purpose in the wrongful death action because it's totally separate of the other case. I don't understand why he can't get that straight. The July 8th deposition date and the July 14th federal hearing date make a stay particularly compelling. The temporal relationship between the commanded deposition date and the scheduled federal hearing date is striking and dispositive on the question of a stay. And the deposition date is only that close to the federal hearing date because you needed to reschedule the deposition. The deposition was supposed to be held in June. Karen Reed, which after you had them change the date, you had time to file this motion to quash the deposition. So the fact that they were able to accommodate you in rescheduling your deposition date just helped in giving you time to file this motion, which is bullshit. Karen Reed's subpoena commands Tully to appear for deposition on July 8, 2026. Judge Casper has scheduled oral argument on the motions to dismiss, including Tully's, for July 14th. Tully is thus being commanded to submit to a wide-ranging deposition as a federal defendant 6 days before the court overseeing his federal case hears argument on whether he belongs in that case at all. It's not the same case. I don't understand that. No legitimate discovery purpose in this wrongful death action requires that Tully be deposed on July 8th rather than after July 14th. The O'Keefe plaintiffs, who are the parties to this action, have not sought this deposition. Well, no kidding. They don't want to depose you because they don't want to hear what actually happened to their son. They don't want to hear anything other than Karen Reed did it. And they have to prove that John was even hit by a car before they can even put on a case against Karen. And as far as I'm concerned, they have not even attempted to depose any witnesses that can change that. It is Karen Reed's subpoena, served by the defendant in this case against a non-party who is her own federal defendant, timed to extract testimony from Tully immediately before the federal court rules on whether her claims against him are legally viable. A brief stay of fewer than 2 weeks would cost the parties nothing while allowing the federal court's threshold ruling to inform whether and on what terms Tully's deposition in this proceeding is appropriate at all. And I don't think the federal court's going to rule on that. The federal court's only going to rule on whether or not the case against him by Karen Reed gets dismissed or not. They aren't deciding anything as far as this wrongful death case goes. The chronology of this litigation confirms the improper purpose of the subpoena. The sequence of events in this litigation tells a clear story. Tully filed his initial motion to dismiss the original complaint in the federal action, identifying the factual and legal deficiencies in the claims against him. Rather than oppose that motion, Karen Reed filed an amended complaint on March 13th, attempting to cure those deficiencies, but doing so, as Exhibit A demonstrates, primarily by inserting Tully's name into existing allegations and appending, quote unquote, upon information and belief assertions without factual support. Tully filed his motion to dismiss the amended complaint on April 3rd, again identifying with particularity the absence of specific, non-conclusory factual allegations against him. This subpoena was served 32 days later. The federal MTD hearing is now scheduled for July 14th. The commanded deposition date is July 8th. The 15 document categories in Schedule A track the factual gaps in the amended complaint with precision. Request 5 seeks documents concerning individuals at 34 Fairview Road. The same individuals whose investigation the amended complaint alleges Tully failed to pursue. Request 11 seeks communications of with the Norfolk DA's office directly tracking the amended complaint's allegations concerning coordination between MSP and NDAO. Request 12 seeks all documents concerning Michael Proctor, the subordinate officer whose conduct underlies the supervisory liability count. Request 13 seeks Tully's own disciplinary records expressly referenced in the amended complaint at paragraph 140. Schedule A is not a discovery instrument designed to develop evidence for this wrongful death action. It is a vehicle for building the factual record that amended complaint failed to plead and that federal pleading standards required it to contain, extracted from Tully on the eve of the federal hearing at which those pleading failures will be argued. This court should not permit its process to be used in this manner. The appropriate remedy is to quash the subpoena in its entirety. At a minimum, a stay pending the July 14th federal hearing and its resolution is compelled by the circumstances. The document requests in Schedule A are facially overbroad, disproportionate to the needs of this action, and impose undue burden on a non-party witness. Independently of the parallel proceeding ground, the document requests in Schedule A must be quashed or substantially modified because they are unreasonable and oppressive on their face. Rule 45B requires that this court quash a subpoena that subjects a person to undue burden. The standard for evaluating burden on non-party witnesses is deliberately more protective than the standard applied to parties. Schedule A's 15 categories demand, without meaningful limitation, every document, communication, email, text message, audio recording, or video recording in Tully's possession touching the following subjects. 1. Karen Reed, her family members, agents, attorneys, and representatives without any subject matter or temporal limitation beyond January 1, 2021. 2. The 2021 black Lexus leased by Karen Reed. The death of John O'Keefe III without temporal limitation. John O'Keefe II, Paul O'Keefe, or Margaret O'Keefe from January 1, 2021 to the present. 12 named individuals present at 34 Fairview Road on January 28, 29, 2022. From January 1, 2021 to present. Any member of the Canton Police Department from January 28, 2022 to present. Any member of BPD from January 28, 2022 to present. 34 Fairview Road, Canton, Massachusetts, without limitation. Any dog owned by any member of the Albert family. Any federal investigation relating in any way to the death of John O'Keefe III. That'd be interesting. All communications with the Norfolk DA's office that from January 28, 2022 to the present concerning Karen Reed or any prosecution involving her. All documents and communications concerning Michael Proctor from January 28 to the present. All documents concerning any disciplinary investigation, proceeding, decision, or appeal concerning Tully's own conduct as an MSP employee from January 1, 2021 to present. All documents, and so he would have to explain why, after Karen Reed's case, he was demoted from a lieutenant to detective and rehomed. All documents concerning any disciplinary investigation concerning Michael Proctor's or Yuri Buchanan's conduct. All non-privileged documents and communications concerning this litigation or any other current, past, or potential litigation involving Karen Reed. The requests are not tailored to the claims in this wrongful death action. This is a wrongful death action brought by the O'Keefe family against bar establishments and Karen Reed. Tully is not a party. His relevance to this action, if any, is narrow and relates solely to his supervisory role in the MSP investigation that followed Mr. O'Keefe's death. He was not present at the scene on January 28, 29th, and was not involved in the events giving rise to Mr. O'Keefe's death. Did not serve alcohol to any patron, and was not a primary investigating officer. None of the 15 document categories is calibrated to the narrow relevance. Instead, they demand the entirety of Tully's communications, documents, and records touching the O'Keefe matter in all its dimensions: criminal, civil, federal, disciplinary, over a period of more than 5 years. Well, if you didn't have that much involvement in his case and his investigation, then you shouldn't have that much to turn over. So what's the big deal? This is not proportionate discovery directed at a non-party supervisory witness in a wrongful death action. It is a wholesale demand for every piece of paper and every electronic communication that Tully has generated or received in connection with the most prominent and heavily litigated matter of his career. Well, at least he acknowledges that. The burden this imposes on a retired officer without the institutional resources of an active government agency is substantial and unjustifiable on the record presented. Poor Tully. Several categories are independently objectionable. Request 13, demanding Tully's own MSP disciplinary records, is particularly improper. No, it's not, because he was disciplined after her case. So it was obviously in part to something that he did in reference to Karen Reed's prosecution. So it has everything to do with it. Personnel and disciplinary records of law enforcement officers are subject to heightened protection. Such records are not freely obtainable through civil subpoena directed at the officer himself, and their compelled disclosure raises concerns that go well beyond proportionality. Moreover, this request is transparently aimed not at developing evidence relevant to this wrongful death action, but at obtaining material directly relevant to the federal action in which Lieutenant Tully's disciplinary proceeding is expressly alleged in the amended complaint at paragraph 140 and cited in Exhibit A's motion to dismiss as an attempted but legally insufficient substitute for the specific factual allegations required. Requests 6 and 7 demand every communication Tully has had with any member of the Canton Police Department or BPD, a period of more than 4 years with no subject matter limitation whatsoever. A retired officer cannot be expected to locate, collect, and produce 4+ years of departmental communications in response to a third-party subpoena, particularly where those communications span agencies and matters far beyond the scope of this wrongful death action. Just 1 second. Requests 14 and 15 demand records of third-party disciplinary proceedings concerning Proctor and Buchanan and records of all litigation involving Karen Reed, including the federal action itself. Documents generated in or related to the federal action in which Reed is suing Tully are not obtainable through a subpoena directed at him as a non-party in this case. Request 15 is particularly circular. It asks Tully to produce, as a non-party in this wrongful death action, documents relating to the federal civil rights case in which he is a named defendant and in which formal discovery has not yet opened. If this court declines to quash the subpoena in its entirety, Tully respectfully requests that the court enter a protective order narrowing the document requests and deposition as follows. Staying this deposition pending the July 14th hearing on Tully's motion to dismiss in the federal action and the resolution thereof, so that the federal court's threshold determination of whether any claims survive against Tully may inform the scope and necessity of his deposition testimony in this proceeding. Limiting document production to materials specifically concerning Tully's direct supervisory communications regarding the O'Keefe investigation during the period of January 29th through December 31, which are in his possession, custody, or control. Excluding request 13 in its entirety, as Tully's own personnel and disciplinary records are protected from compelled third-party disclosure and are not relevant to the claims asserted in this wrongful death case. Excluding requests 14 and 15 in their entirety, as they seek records of parallel proceedings and third-party disciplinary matters that are not within Lieutenant Tully's custody or control and are not relevant to this action. Limiting requests 6 and 7 to communication specifically and directly concerning the O'Keefe investigation during the period of January 29th through December 31. Conclusion. Karen Reed has twice attempted through the federal pleading process to establish a viable factual case against Lieutenant Brian Tully. She filed an original complaint. Tully moved to dismiss it. She filed an amended complaint. Tully moved to dismiss that as well, demonstrating, as set forth in detail in Exhibit A, that the amended complaint's expanded allegations remain conclusory, rely on impermissible group pleading, and fail to plead the specific facts that subsection 1983 claims require. Judge Casper has now scheduled a hearing on the motions to dismiss for July 14th. In the federal action, Karen Reed successfully opposed co-defendant Proctor's motion for pre-conference third-party discovery, obtaining a ruling from Judge Casper that such discovery is not appropriate in advance of the Rule 16.1 and Rule 26F process. Having secured that ruling, she now seeks to use the court's subpoena power to compel Tully, her own federal defendant, to submit to a sweeping deposition and produce 15 categories of documents on July 8th. 6 days before the federal court hears argument on whether her claims against him are legally viable at all. That is precisely the pre-conference third-party discovery that the federal court has already declined to authorize, repackaged as a state court subpoena and directed at a different target. For the foregoing reasons, this court should quash the subpoena and document requests served upon Lieutenant Brian Tully in their entirety. In the alternative, this court should enter a protective order, 1, staying the deposition until after the July 14th hearing, and 2, substantially narrowing the document requests to the specific categories identified in Section 2C above. Respectfully submitted for the non-party witness, Lieutenant Tully, by his attorneys. This is his motion to dismiss plaintiff's amended complaint and memorandum in support thereof. So I've already gone over those in the previous stream. These are the differences between the original complaint and the amended complaint.
Failure to search the house, interview house defendants. And Tully now explicitly named alongside Proctor Buchanan in each specific investigative failure. Failure to investigate Higgins, 90-minute discrepancy regarding Caitlin Albert. Failure to pursue Ford Edge, Brian Loughran. Tully specifically named as having made no effort to track down snowplow operator. Hiding CPD surveillance video. Then it wasn't alleged against Tully at all originally. Now Tully alleged to have collaborated with CPD to hide a exculpatory surveillance video showing Higgins' activities at CPD. McCabe and Sergeant Lank meeting, not alleged against Tully. Tully met with McCabe and DAO only after Miss Reed's attorneys revealed McCabe's visit to Sergeant Lank's home. Neither Tully nor anyone else memorialized that meeting at McCabe's visit. MSP discipline reassignment. Tully disciplined and reassigned. Stripped of detective designation. No, he was stripped of lieutenant designation. Proctor admitted informing Tully and others in February 2024 of prejudicial texts and messages. Albert relationships. No member of the chain of command sought discipline until after Miss Reed's. Yes, because remember, he in his recorded deposition in Proctor's firing, he said that he and Good, was it Good or Fanning? No, he and Fanning went over to Proctor's house after Proctor testified to the grand jury to see if he was okay, because Proctor's text messages were brought up to him in the grand jury, and he was caught off guard, and he was upset. And so they went on over there to check on him to see if he was okay. So he knew about his misconduct. And he never said anything to anybody. Malicious prosecution. Tully named as a defendant, expanded, now includes detailed sub-allegations specifically listing Tully's alleged conduct as direct participant, not merely supervisor. So this is just how all the two motions differ, and we covered that in the video about his motion to dismiss. So this is his subpoena. That's the schedule of the definitions of everything that they're asking him to bring with him to the deposition. Same thing that was in Colin Albert's subpoena, etc. And this is Michael Proctor's motion to conduct limited discovery, which we've gone over already. And that is that. So that wasn't as long as I thought it was going to be. Before I end this stream, there is one thing that I wanted to go over, and that is Alvin Campbell had his sentencing hearing yesterday, and it was not streamed, which I figured it probably wouldn't be, because if the victims wanted to make it victim impact statements, how would they stay anonymous, if they were being streamed? So it doesn't surprise me, but I do have the story on it that I will share with you right now. And I think that you will find that it is good news all around. Okay. Alvin Campbell sentenced to life behind bars in serial rape case. Mr. Campbell, you pretended to be a safe harbor, is what it says. He's a big man. Serial rapist Alvin Campbell Jr. was sentenced to life in prison Monday after being found guilty of 21 charges, including aggravated rape and kidnapping earlier this month. Campbell was also sentenced to serve 120 to 140 years concurrently with the life sentence. Prosecutors said it eliminates his chance for parole. Campbell, who's the older brother of State Attorney General Andrea Campbell, was on trial for assaulting 7 women while posing as a rideshare driver, picking the victims up when they were extremely intoxicated and often videotaping their sexual encounters. The jury found Campbell guilty on all counts except for a single rape charge. Judge Mary Ames declared a mistrial on that count, and prosecutors said they planned to enter a motion to dismiss it. Quote, Mr. Campbell, you pretended to be a safe harbor, end quote, Ames said at his sentencing. Quote, there was violence done to each woman in the act of rape, end quote. In deciding the sentence, Ames said she considered Campbell's quote unquote long and violent history, which included gun charges and assaults, as well as the evidence presented at trial and the statements of several victims. Quote, even though the assault occurred on a single night, I have lived with the consequences every day since, end quote, the only victim to speak in person said at the hearing. After the assault, she sought a rape kit, moved out of her apartment as she was afraid that Campbell, who knew where she lived, might come find her, and spent thousands of dollars on therapy. On the day jury selection for Campbell's trial began, the victim's wife gave birth to their first child. Quote, arguably the most important day of my life was clouded by Alvin Campbell's actions, end quote. Looking at the judge, she said, quote unquote, I don't ask for the maximum sentence lightly. Then looking at Campbell sitting in a gray outfit next to his lawyer, she noted that he had not taken any responsibility for his crimes. Before that night, I had never felt unsafe, end quote, wrote another victim who was picked up by Campbell in Fenway while she was trying to walk home from a bar. But afterwards, she wrote, quote, I looked over my shoulder because I truly feared this man was watching me, end quote. She wrote that for years she had night terrors and couldn't tell anyone about what had happened to her. To this day, she still hasn't told her father. In another statement, one of the victims wrote that it was, quote unquote, disgraceful how Campbell had tried to excuse his behavior. She called out his attorneys, who she felt mischaracterized and belittled the victims. Despite the, quote unquote, hell of going through the trial, the victim wrote she'd do it all over again to ensure that the defendant would remain behind bars. Quote, on our behalf, end quote, she wrote to the judge, quote, please give him the sentence that he deserves, not the sentences that he requests, end quote. Campbell's lawyer, Andrew Carosi, asked for an 18-year sentence to be followed by a lengthy probation period. Several people sitting in on the hearing shook their heads while he spoke. During his statement, Carosi argued that under his recommended sentence, his client would be almost 60 years old by the time he was released from prison, and cited studies that show sex offender recidivism rates decrease with age. Tell that to Aaron Spencer. His daughter's attacker was 67 years old. So that doesn't really hold water. The defense attorney also tried to argue that Campbell should be sentenced for, quote unquote, simple rape rather than aggravated rape because of a lack of force during the crimes, which the judge disputed. Only because they were incapacitated, he didn't have to use force. The defense lawyer also said that the early incarceration of his father, the death of his mother, and living in foster care had all shaped Campbell and led him to a life of crime. Before Campbell was most recently arrested, Carusi said, quote, he'd been trying to rebuild a life with his girlfriend, end quote, who gave birth to their child after he was incarcerated. Quote, he enjoys being a father, and from what I can tell, he's a good one, end quote, Carosi said, telling the judge that his suggested sentence would give Campbell the opportunity to be a father when he got out. Carosi finished his statement by calling the prosecution's recommendation several decades shorter than the actual sentence a, quote, lock him up and throw away the key approach, end quote. Prosecutors had asked for a sentence of between 88 and 100 years, citing Campbell's criminal history, the severity of the crimes, and the need to protect the women of Boston. This was a part of a criminal scheme. ADA Aaron Murphy said it would be unrealistic to consider rehabilitation. When asked after the sentencing whether Campbell got what he deserved, Murphy responded, and then some. Absolutely, he deserved this. His conduct warranted it, she went on. And if we are balancing his wish to be free against the safety of women in Suffolk County, we're going to prioritize the safety of the women in Suffolk County every time. So there you have it. So yeah, thank God. So that's all I have for this video, and don't forget to like and subscribe. It's free, and I appreciate those of you that have. And until next time, don't forget that tomorrow is always the first day of the rest of your life. So if it's going bad today, it can only get better tomorrow. So ciao for now, until later.